Start. It is important to note in this connection that the principles of liability governing civil actions and criminal prosecutions based on negligence differ in two material aspects. Stop. Firstly, in a criminal case such as one under Section 304A or 337 Indian Penal Code, the negligence which would justify a conviction must be culpable or of gross degree and not the negligence founded on a mere error of judgment or defect of intelligence. Stop. Para. Secondly, the principle of avoidance of liability when there is contributory negligence by the injured person is no defense in criminal law. Stop. But in the absence of a statute analogous to the English statute, namely the Law Reform within bracket contributory negligence bracket close Act 1945 in India, contributory negligence may be a rude defense to a civil action. Stop. Para. Furthermore, the nature of the onus, the approach to and effect of the evidence in a criminal case is materially different from that in a civil action. Stop. In criminal cases, the prosecution must pursue the guilt of the accused beyond the utmost bounds of doubt to a point of moral certainty. Stop. But in civil cases, mere preponderance of probability may be sufficient to fasten the defendant with liability. Stop. The reason is not that the Evidence Act prescribes different standards of proof in civil and criminal cases, but because under that act the burden of proving the guilt of the accused beyond all manner of doubt always rests on the prosecution and never shifts on to the accused. Stop. This is not so in civil cases. Stop. Para. To sum up, in civil actions and criminal prosecutions arising out of the same motor accident involving bodily injury or death, the parties may be different, the issues may not be identical, the nature of the onus may vary, and the effect of evidence may not be the same. Stop. It will therefore be contrary to all fundamental concepts of natural justice to treat the findings of the criminal court as binding on the motor accidents claims tribunal, assuming but not holding that such a tribunal is not a court as defined in Section 3 of the Evidence Act, but partakes the character of an arbitrator with most of the trappings of a court. Stop. Para. It will therefore be opposed to fundamental canons of justice and public policy to treat the judgments of the criminal court binding on a motor accidents claims tribunal trying a claim arising out of a motor accident involving injury or death. Stop. The judgment of the criminal court can at the most be used only for the purpose and to the extent indicated in Section 43 of the Evidence Act. Stop. Para. For the reasons recorded in separate judgments, we answer the question referred to us in the following manner and direct that this appeal will now go back to the learned single judge for disposal on merits in accordance with law. Stop. Para. The judgment of a criminal court in a prosecution arising out of a motor accident determining the guilt or innocence of the driver of the motor vehicle concerned is neither conclusive nor binding on the Motor Accidents Claims Tribunal under Section 110 of the Motor Vehicles Act, and its findings as to the guilt or otherwise of the driver are wholly irrelevant for the purpose of the trial on merits of the claim petition before the Motor Accidents Claims Tribunal. Such judgment can, however, be relevant only for the purpose and to the extent specified in Section 43 of the Evidence Act. Para. Costs of this reference shall be costs in this appeal.